Abhishek Manu Singhvi.
Chair, I am very grateful for this opportunity to reply to a very balanced and a sober speech by my friend. But I am also replying to those who follow him and not merely to him. And I don't expect the same sobriety and balance to be continuing a little later. So may I start, Mr. Deputy Chairman, sir, by saying that here is unfortunately a government, an insecure ruling party and perhaps a historical government affected by increasing disillusionment with its non-governance, trying to foist a charge of corruption against persons unconnected.
Yeah.
And I want to make it good purely factually. I hope the House will give me some attention. I will not make unnecessary allegations. And remember, nobody is saying that everything is hunky-dory with this deal. It is we who have a CBI, a Enforcement Directorate, inquiry, a cancellation, a recovery of 2,000 crores, an impounding of 3 helicopters. So obviously there was wrongdoing. The first point we have to see is whether the wrongdoing is where my friends are pointing by innuendo and insinuation and nothing more. And I think we owe it to this country and to this House to have more sense and less sensationalism, more facts and less falsehood, and more detail and less diversion. Let me suggest to you,
No, please.
He is not Indian.
No, you please. No, take your seat. I will deal with that. आप लोग बैठिए, I will deal with that. आप लोग बैठिए. Please resume your seat. What is your point of order? What is your point of order?
Point of order
What is
is
your point of order?
that the honorable member has cast an aspersion on the House.
No.
Because the House
I am
should
doing the
not be-
opposite, sir. I am doing the opposite.
You check the record.
I will go
through the
The
record.
word should be expunged. Because it is an aspersion on the House.
I will go through the record. If
Yes.
there is aspersion against the
Yes.
House, I will delete it.
Yes.
Please. Chodo, let it speak. Let it speak.
I am astonished when I am doing the opposite of my friend is saying, and he's saying I am casting aspersion. But let us go, sir. Let me take the bull by the horns. Let us travel seriatim from the CP to the VP to the AP. Let us take it straight away. Now let us look at the head of a party here who is tried to be vilified. The totality of this Italian judgment, whose official translation we still don't have, has this to say about that person. It's a letter written to one Peter Hule by Hashke, who says, "Dear Peter, given that Mrs. Gandhi is the driving force behind the helicopter, behind the deal, she will fly no longer with MI8. Mrs. Gandhi and her closest advisors are the persons that the English ambassador should. These persons should be addressed by the English ambassador. The English ambassador in India is called the High Commissioner. The advisors are listed hereby." And then after one para, he says the advisors are the Prime Minister, Ahmed Patel, Pranab Mukherjee, Narayanan, Oscar Fernandez, etc. Now, sir, whichever way this sentence is read, howsoever distorted it is read, I want to ask myself, does it suggest that anybody talked to any of these persons to offer a bribe? Is it not plain English that they are stating the obvious, that people who use and fly on these helicopters are VVIPs and they would not want to fly in old, outdated machines called MI8? On this logic, everybody mentioned in the next paragraph, from the current president to several other names, are all culpable merely because they find a mention. Sir, is this the way we have to tilt and windmills? There is not anything here about anybody except a statement of fact that VVIPs travel in these helicopters, and these helicopters would be required because the old helicopters would not be acceptable to them. And I hope nobody is suggesting that the advice of Mr. Hashke is to request the British ambassador to go and bribe these people. Second, this judge who wrote this judgment, more than 1,000-page judgment, he's called the president, Judge Maiga. How did he understand this detailed inquiry over 1 year? We have had his benefit. You know, the Italians have an inquisitorial system whereby judges can speak even after the judgment, not like our adversarial system. So the judge speaks extensively to a channel in India. And I'm only quoting that part about the CP. We'll come to the VPs and the APs later. He says, we have no evidence against Sonia. I'm quoting, unquoting. We have no evidence against Sonia Gandhi. Only a mention of her in a fax. The translation of the fax was sent to Mr. Michel. Ms. Gandhi has been indicted as someone who will, indicated as someone who will fly in the VVIP helicopters. The same place is the mention of Mr. Manmohan Singh. This manuscript was found in the jail of Mr. Orsi. He wrote this slip of paper with the names of the Italian Prime Minister, the Indian Prime Minister, the ambassador, etc. So now, are we, sir, with great respect, this proud, largest democracy in the world, a banana republic, that we have no faith in our courts? We have a faith in a misreading of an Italian court whose president says the correct way to read it is this. The president is saying this of that court. Thirdly, Mr. Chairman, sir, we are relying on not a single finding by an ED and a CBI, not a single finding by any authority in India, and on interpretations and miscalculations and distortions of Italian court judgment. This is actually a vote of non-confidence. As a matter of fact, I am so happy that this judgment in the next sentence says FAM, family, is Tyagis. Otherwise, I am sure there are many people here who would say family means only one thing in this country. Fortunately, the word family is followed by Tyagis. Let us now leave this. That is the totality of this big storm in a teacup about the president of a political party. Totality. You can search the whole judgment. I've spent time on it. Let us look at now the VP. The poor VP has no mention in this judgment. He has no mention. His assistant has no mention. So a very, very honorable member of parliament suggests that because that VP secretary has been on a company with this Hashke, therefore direct charge of corruption is against the VP. Sir, we are all responsible parliamentarians. I can expect it from a common man. I cannot expect it from this house or any member of both the houses. The gentleman concerned, two very interesting admitted facts. One, he has, that is the aide of the VP, the assistant of the VP, has never before, current or after, been a shareholder or stakeholder in any form in the company mentioned. Please haul me up for privilege if this is false. This has been said outside, it's been said inside. Second, he has never before, current, or I don't think he intends to be a director in the future. Not shareholder, not director. Now the interesting part. This company belongs to Guptas. The patriarch Gupta is his Nana. The current Gupta is the Nana's son, his Mama. They have fierce litigation between the two sides for the last 10 years, not on talking terms, suing each other because the Mama is supposed to have taken the estate by a forged will, for which a case is going on in Tis Hazari. I think the happiest person in this country, if these people go to jail, would be that aide of the VP.
Yes.
It is said that that VP's aide conspired with this person when he has not been a director or shareholder. Now let us turn, sir, to AP. There are a lot of APs in this country. There is an AP heading Gujarat also. I hope we don't collect all the APs together when we talk of APs. That illustrates the problem when you start using initials. Now I'll tell you something very interesting. This AP issue, many years ago, by the way, I must tell you one very interesting which is not quoted frequently. When this AP issue comes, one sentence is not read by anybody, including my friend who's going to follow after me to speak. This is the judgment of the Italian court who says, they ask Hashke, and Hashke says this. I'm only reading the part about AP. There's one sentence. AP, I do not know what it means, what it stands for. Then the next page, the prosecutor says, not the witness. Witness has said, I do not know what AP stands for. Then a man called D. Vinere manages to fill in the gaps. He says, and I'm quoting, from open sources, we could see on the internet that AP stands for Ahmed Patel. Why did he not think of the Chief Minister of Gujarat? Why did he not think of so many other APs in this country? I'll tell you why. I'll tell you why. Many, many years ago, the leader of this house had occasion to answer this question. I'm sorry he's not here. Many years ago, the leader of this house answered that question. When a diary was found which had many initials, one of the initials was LKA. Those were happier days when LKA was not part of Margdarshak Mandal. Now what happened was, LKA along with other people challenged in a court of law. That judgment stands as Indian law today for the last 20 years. It was very ably argued, assisting Mr. Jethmalani was the leader of the house. I don't know why he's practicing double standards now. I'm only adopting his arguments. He argued that initials have no evidentiary value. Anybody can pick up a diary and write any initials. Assuming all the initials are correct, and there are paras in that judgment is final of the Delhi High Court. I have a whole copy of the judgment. It gives the date when that initial received a total of 65 lakhs in 3 tranches. The court held, accepting the argument of many counsel, including the leader of the house here, that initials have no value. Assuming everything is correct in the diary, it can't lead to a charge, much less a conviction. And he quashed the trial before the trial had begun. That is what the Indian court says. We are now tilting at windmills in Italian court, which has not even said that. The Italian court witness says, I don't know who AP stands for. So we should not practice double standards. I want to remind you, I'm not taking names. There is a state in this country, there is a chief minister of that state. His wife's name appeared when everybody on that side argued that that reference to the female version of a mantri cannot refer to anybody because it's a diary entry. Mantrani was the word used. That was the same thing. How can you have hypocrisy and double standards? Just because you have a vicereal, you have an inbuilt hatred for certain names. We have to be more mature and more balanced. Friends, there is again the same president of the same tribunal who had this to say about AP. The earlier part was about the CP. Now he said this about the AP. I'm reading 3 parts. His whole interview to the Indian channel, almost 10-15 minutes, is available. 3 parts he says, but we have not individually verified their exact role in this case. Secondly, they're all quotations. The traces are not so clear or so heavy for me to ask them anything. Third, this is just a hypothesis, not a direct evidence. We have no direct evidence. This is a separate part about the AP. Fourth, no evidence about AP. It is not our specific interest to indict him. He is not essential to even our investigation. He is around the principal story. Now, on that, we want to vilify, we want to convict, we want to sensationalize, we want to breastbeat. Let us now leave this, and that is the story of the CP, the VP, and the AP. Now, about this semantic dispute, totally unnecessary, about banning or blacklisting. Actually, the truth is always more important than semantics. बड़ा सरल उत्तर है इसका. 2014 फरवरी में यूपीए सरकार ने प्रतिबंध करने की प्रक्रिया शुरू कर दी थी, बैनिंग की, औपचारिक रूप से शुरू कर दी थी. मैं शब्द जानबूझ के बैनिंग कर रहा हूं जिसमें न उनको विरोध है न मुझे. उसके बाद उस वक्त के एएसजी की ओपिनियन आई कि क्योंकि आप बैंक गारंटी पे बहुत रुपए मांग रहे हैं और उसकी अपील पेंडिंग है, तो बैनिंग को कंप्लीट अभी नहीं करिए. उन निर्णयों के लिए जो विदेशी कोर्ट्स में उनके लिए थोड़ी इंतजार करिए. इसलिए जो प्रक्रिया शुरू की यूपीए ने वो थोड़े समय के लिए धीरे हो गई. चुनाव आने वाले थे, चुनाव आए, सरकार बदली. इस सरकार ने 3 जुलाई 2014 को एक टेम्पररी बैनिंग ऑर्डर पास किया. इंसिडेंटली उस ऑर्डर के ऊपर लिखा है और भी सरकारी दस्तावेजों में लिखा है बैनिंग ऑब्लिक ब्लैक लिस्टिंग. तो बैनिंग और ब्लैक लिस्टिंग में ज़्यादा फर्क नहीं मानती है सरकार भी, लेकिन उसको छोड़ दीजिए. मैं बैनिंग की शब्द इस्तेमाल करता हूँ. प्रतिबंध करने के लिए आंतरिक रूप से 3 जुलाई 2014 को एक ऑर्डर पास हुआ. यहां तक सब सही है, हमने भी किया, आपने भी किया. इसके बाद जो हुआ वो बहुत रहस्यमय है. उसी दिन जिस दिन 3 जुलाई 2014 को माननीय मोदी जी की सरकार ने यह प्रतिबंध करने का आंतरिक आदेश किया, उसी दिन उस वक्त के रक्षा मंत्री आज वाले रक्षा मंत्री नहीं, उन्होंने रेफर किया अटॉर्नी जनरल को एक प्रश्न कि इस बैनिंग में क्या अपवाद हो सकते हैं, और अटॉर्नी जनरल का 40 दिन बाद उत्तर आया, और उस उत्तर के आधार पे 22 अगस्त 2014 को एक बड़ा विचित्र दस्तावेज जारी हुआ, जिससे कि आंतरिक प्रतिबंध को कायम रखते हुए उसमें इतने अपवाद निकाल दिए कि अपवाद उस रूल को खा गया। मैं आपको 3 अपवाद पढ़ देता हूं। आइटम ये है, सरकार का दस्तावेज है, मेरा नहीं है, 22 अगस्त 2014 का। एक्सेप्शन 1, where contracts are under execution when one or the other company under the umbrella of Finemecanica group of companies, यानी अगर इस कंपनी के अलावा इस ग्रुप की कोई और कंपनी है तो क्या वो प्रतिबंधित है? आंसर नो, देयर इज नो रीजन नॉट टू प्रोसीड विद द कॉन्ट्रैक्ट्स। बड़ी विचित्र बात है, हमने तो बात करना बंद कर दिया। 2013 से हमने किसी रूप से किसी फिनेमेनिका, अंग्रेजी या इटालियन ऑगस्टा से बात करना बंद कर दिया। ये कहते हैं कि अगर वो कंपनी के अलावा अम्ब्रेला कंपनियां हैं तो कोई आपत्ति नहीं है। दूसरा, वेयर कॉन्ट्रैक्ट हैज ऑलरेडी बीन एग्जीक्यूटेड बट स्पेयर्स अपग्रेड्स आर स्टिल रिक्वायर्ड, देयर इज नो रीजन नॉट टू डील विद देम। चलिए, स्पेयर्स में समझ सकता हूं, आवश्यकता हो सकती है, यद्यपि हमने उतनी भी बात नहीं की थी। अब सबसे विचित्र बात है तीसरा, जो आखिरी है, 6ठे नंबर पे, 3, 4, 5 रेलेवेंट नहीं है। दिस इज वेरी इंटरेस्टिंग। This encourages camouflage, disguise, deviation. It says where a vendor is a subcontractor, should it matter that one of the subcontractors is such a company? It should not matter that a company under the Finemenica group of companies is a subcontractor supplier to a contracting party with the government of India. अभिषेक सिंघवी सरकार से डील नहीं कर सकता, लेकिन अभिषेक सिंघवी प्रमोद तिवारी को सप्लाई कर सकता है, प्रमोद तिवारी सरकार को सप्लाई कर सकती है। ये तो कानून, मैं समझता हूं कि वकीलों को एम्बैरेस करने वाला ये कानून का एक इंटरप्रिटेशन निकला है। ये आपका दस्तावेज है 22 अगस्त 2014 का। अभी जो बौछार थी लार्जेस्ट की, वो रुकी नहीं थी, क्योंकि इसके कुछ समय बाद 8 अक्टूबर 2015 को FIPB, अब ये आजकल इसके ऊपर विवाद चल रहा है कि रक्षा मंत्रालय वित्त मंत्रालय से बात कर रहा है जब से ये छूटी है बात, लेकिन सच्चाई है 8 अक्टूबर 2015 यानी मोदी सरकार के लगभग 1.25 साल बाद या 1.5 साल बाद, उसमें रोटोक्राफ्ट, इंडियन रोटोक्राफ्ट लिमिटेड को फॉरेन इन्वेस्टर की हैसियत से अनुमति दी गई। वो फॉरेन इन्वेस्टर सिर्फ अगस्ता वेस्टलैंड था। सब लिखा है, दस्तावेज है, आपका ऑफिशियल डॉक्यूमेंट है 8/10/15। What I am astonished is that when this point was raised by us at a press briefing, the answer was very funny. The answer was, yes, we, the FIPB in the Modi government, have issued it, but you gave them an industrial license in 2012. Sir, how is that a relevant answer? In 2012, there was no AgustaWestland issue. And I would like to ask, if the president of the ruling party calls this a bogus company, quote unquote, just 4 days ago, then surely the government respects its own president of its ruling party. They should have asked him before issuing a FIPB approval for foreign investment to this so-called bogus company.
Shame. Shame.
This tainted company is further allowed, sir, on the 18th to 22nd of February 2015 to enter the Air Force Station at Yelahanka, Bangalore, and participate in the aero displays. This is on 18th February 2015. I want to remind you, sir, that this is the company which the president of the ruling party calls a bogus company or a tainted company. Now, when a question was asked to the defense minister, the present defense minister, quite rightly on the 4th of March, he said, which is the only proper answer he can give, but 24 months CBI is going on. We have got none of these evidences which you are imagining in the Italian judgment from one sentence.
Sleeping.
For 2 years, the CBI or the ED has got nothing. The Honorable Defense Minister says, quote unquote, finalization of investigation by CBI is dependent on execution report of the pending letters rogatory from 8 different countries. This is the status on 4th of March 2016, this year, a month ago. Let me very quickly proceed further. My time is limited, Mr. Chairman, sir. What did the NDA do, the Modi government do? I have dealt with. What did the UPA do? Is this the conduct of high government political officers who have taken bribes. The UPA did the following. This broke for the first time somewhere in March or so, 2012. On 19th April, Defence Minister writes to both CBI and ED to inquire. Both official agencies. The ED accepts that on July 12 in writing. In July itself, the Indian Embassy in Rome is asked to go to the Napoli Public Prosecutor's Office to collect information. They say we cannot give, it's hit by confidentiality, secrecy, we cannot give. All information is sent in that month itself, or rather a few months later, to the Director General of Income Tax. A case is registered by the CBI, what is called a PE, in February 2013. A show cause notice of cancellation is issued in February 13. The contract is cancelled in January 14. A first set of papers come in May 13. So in July and December 13, 8 sets of letters rogatory are issued. The countries involved are Tunisia, Mauritius, Italy, England, etc. 8 sets are issued. This is the conduct of a government which wants to hide its top political leadership. On 27th of February in this house, Rajya Sabha, a specific proposal is made to have a JPC. Our friend sitting there oppose it heavily. That's 22nd of February 2013.
Why?
JPC क्यों बना कि
This
भाई
is a very
बता दो।
interesting corruption charge. This is a very interesting corruption charge. I must give you some figures. The total money admittedly paid to this company is 1586 crore, 1586 crore. हमने अभी तक यूपीए में, I repeat, only in UPA, not in NDA, we have recovered 2062
My
crores.
God, my God.
Sir, in the defense, 2062 crores, 2000, 2062 crores came by way of a...
प्लीज रिपीट योर आप आंकड़ा रिपीट कर दीजिए कोई बात नहीं लोट नहीं
2000, no, I'm sure he has lots of good
Yes,
answers.
please.
2062 crores came out of 224 crores of bank guarantee we encashed immediately, and 1881 crores on a case we lost, we appealed and we won just around the time the new government was coming, but it was all done in our time. Now this is without counting, sir, 3 additional helicopters we impounded. The cost of each helicopter is 300 crores. So 2062 crores hard cash we have. 900 करोड़ के हेलीकॉप्टर हमारे पास है, यानी लगभग 3000 करोड़ हमारे पास है कैश एंड काइंड में.
दिया कितना?
सर, ये बार बार कहा जा रहा है, मेरे काबिल मित्र यादव साहब ने कहा ये ऑल्टीट्यूड रिक्वायरमेंट. मुझे तो आश्चर्य हो रहा है, ये कौन से ऑल्टीट्यूड की बात कर रहे हैं, किस हवाओं में जा रहे हैं. ये ऑल्टीट्यूड के 3 तिथियां नोट कर लें. इंडियन एयरफोर्स ने कहा था 1999 में, और उनके मुंह से निकल गया था 1999, शायद भूल गए थे कि वाजपेयी सरकार आई थी उस वक्त, कि MI-18 VIP को बदलना है, पुराना हो गया है. ये 99 में पहली बार प्रस्ताव आया अगस्त में. 2002 में वाजपेयी सरकार में RFP इशू हुआ पहली बार, और 4 लोगों ने रिस्पॉन्ड किया. कुछ लोग नहीं कर पाए, ऑगस्टा ने कोशिश की, नहीं कर पाया उस वक्त, क्योंकि वो कोई रिक्वायरमेंट फुलफिल नहीं कर रहे थे कुछ. ये हुआ 2002 मार्च में. तो MI-8 को बदलने का प्रस्ताव शुरुआत हुई 99 में. उस बदलाव के लिए, अरे एक मिनट, उस बदलाव के लिए RFP औपचारिक इशू हुआ 2002 में.
तभी इनकी सरकार.
I'm sorry. You said about single vendor. I'm coming to single vendor. 1 second, let me answer, please.
No, please.
Now, in
No,
1911, 2003, the Principal Secretary, Mr. Brijesh Mishra, to the PM, used the same language. Do not have the 6,000 altitude because that leads to a single vendor. Single vendor. Yes. The date is 1911-2003. He said, you please consider reducing it. Nobody flies at 6,000 meters. So it was reduced to 4,500 to avoid a single vendor. On 22,
No, please.
on 22/12.
Please don't.
1 minute.
Please
On
don't make noise.
22/12,
I also want to hear it.
On 22 December 2003, on 22 December 2003, when the 4,000, we are still in the Vajpayee Sarkar, 22 December 2003, 6 months before, the principal secretary of the PMO complained saying, we have not been fully again consulted, but the requirement is now finalized at 4,500 meters. What did we do? From March to 2005 to September 6 for 1 year, this was debated by multi-layered institutional paradigms and committees, almost 10-15. And then in 2006, a RFP was issued and etc. The process then went on. Now, we are doubting. Let me also tell you about the field evaluation trials. Let's make that point in 2 minutes. Yes, normally everybody does field evaluation here. But 2 or 3 short points only. First of all, to have a field trial abroad is neither unheard of, nor a sin, nor prohibited. The idea is it prohibited? Is it non-condonable? It cannot be done ever. I have all the 3 government procurement policies of the Government of India Defence Procurement. 2002 की है, उसका पैरा 27 है. 2006 का है, उसका पैरा 38 है. और 2016 का सबसे recent है, उसके पैराज है 65 and 66. They all contemplate the possibility of a foreign trial, although as far as possible, you should do it here, but you can do it abroad also. It's very clearly written in these paras. You can check up. Therefore, it is not a prohibited. It is not a sin. Number 2, there were 2 helicopters at that time, Sikorsky of USA and this Augusta of England, UK. Both were tested, one in UK, one in USA. It was not that Augusta was tested in US and Sikorsky was called here. Both were tested in their home countries. Third, the defense minister reasoned that the norm is this. He was then received by written notice, and I'm sure Mr. Anthony is here, he will explain, by the chief of air staff, the defense people, the secretary. 4 or 5 detailed technical notes came as to why it is permissible to have a foreign trial. He simply agreed. Now, I don't think this is a sin. We are now not talking of something wrong. We believe something wrong happened. This defense minister, the former defense minister, said in the House, yes, we believe prima facie there might have been something wrong, which is why we are having a CBI ED. My dispute is not that. My dispute is, where are you pointing? Because it is important. Is this, what is this that we are all tilting? Are you not allowing the true culprits to escape by this tilting at windmills? By your fixation to finger point only at one person, are you not actually damaging the investigation? If you were to constructively collaborate, would you not finish all these multifarious activities quickly and convict somebody or catch somebody? No. The interest appears to be to keep the pot boiling, not to have a conclusion, and to keep finger pointing. This, unfortunately, can only be ascribed to arrogance. It can also be ascribed to the hubris of power. It may be ascribed to the election defeats after 2014. I don't know. But certainly, I don't think you can intimidate us so easily. I don't think, वो कहावत है कि शाखों से टूट जाएं वो पत्ते नहीं हैं हम. शाखों से टूट जाएं वो पत्ते नहीं हैं हम. इन आंधियों से कह दो औकात में रहें.
क्या बात है, क्या बात है.
May I say, sir?
क्या बात है.
May I say, sir? I'm ending. In half a minute, I'm ending.
Okay.
I'm ending, sir. May I say? May I make an impassioned plea? May I make an impassioned plea? May I, sir, in ending, make a very impassioned and a very respectful plea for restraint, for balance, for moderation. Else we will damage the legal system here. We will damage democracy itself because we will not allow that system to work. We must cooperate constructively and we must avoid hysteria. We must rely on logic. Thank you very much.
Professor Ram Gopal Yadav.